welcome back. This is Newsfile. It's your most authoritative news analysis show. And let me just read some messages that I'm having. This one is coming from Nana Santibidietu. He says, for clarity, what he wants to say is that if you check Article 280, Clause 5, it is either when 6 months have passed after a finding has been made, or the government issues a statement in the Gazette or issues a white paper. So it is not as if you necessarily have to wait, from what I understand him, have to wait for 6 months to pass after the publication. Again, there's another very respected lawyer who says once the publication has been made, they have every right to invoke the supervisory jurisdiction of the court and deal with the matter. They don't need to wait for all the times that are being talked about. The time limit of 6 months is only for appeal purposes. You say you have a different view on that.
Yes, I do. because
Gabby says you don't.
Yes, I do. Because let's look at
deal with that in a minute so that we move on to.
Yes, let's look at 2802, where a commission of inquiry makes adverse finding against any person. The report of the commission shall, for purposes of this constitution, be deemed to be the judgment of the High Court. Then we go to 5. A finding of a commission of inquiry shall not have the effect of a judgment of the High Court as provided under Clause 2 of this article, unless A, 6 months have passed after the finding is made and announced to the public.
6 months have
passed after the finding is made and announced to the public. I take that to be the date of publication. Or the government issues a statement in the Gazette and in the national media that it does not intend to issue a white paper. If the government issues that statement today, that it does not intend to issue a white paper, then we don't need to wait for any 6 months. But until that is done, for me, you can, of course, as it said, it is a commission which is amenable to judicial review.
Right. Thank
you.
So you can. Let's move on to other matters. And still reminding you
does it have to have
that Bank of Africa
of a High Court decision
before you
take an action?
it. And that is only to the appeal. That is what the other opinion, which I subscribe to, says that, and I think is the right opinion, that the 6 months is limited to when you want to appeal.
Oh yes, I agree.
But if you don't intend to appeal, but challenge it in
the Supreme Court, for example.
Way.
Yes, I mean I agree.
Now, let's deal with Dr. Obed Asamoah and he being found of causing a financial loss, as far as the financial loss of 4.9 million to the state. I'll start with you, Yao. So straightforward. You're familiar with this particular process, which had to do with the agric, ministry, and the issue of Delta Foods. What is the commission saying? The Attorney General did wrong.
Well, you see, once again, I think if you are not careful, the people will, even competent people, will be afraid now to go into public service, because this is a judgment or a decision of a lawyer based on his competence and the standard that is required of a lawyer of that station. Apart from that, it also crystallizes into an executive decision, the decision of an executive organ of state. So if we are now going to then require people, or to say that people have committed a financial loss to the state because they took a decision which I would say was made in good faith, because I cannot contradict it. That is what I expect a lawyer to do. Otherwise, then it becomes even a matter of disciplinary matter as a lawyer, and not so much as to make such implicate that person. We will go back once again to this same matter, because here again there is no information that Dr. Obed Asamoah was afforded an opportunity to at least defend himself as a person charged, not just as a witness. And that is why I still have some doubt, but as I say, I've been convinced that this is the report. So once he was not called, but you see the danger with the decision of a commission of inquiry is, as we say, if all the conditions occur, this is going to be with Dr. Obed Asamoah forever. He may have intentions of wanting to become a president. And so I'm even of the view that, you see, somebody, for example, can take the judgment, the Brazil Commission judgment, Commission of Inquiry report, take a portion, and even go to the Supreme Court for an interpretation on whether or for a declaration under Article 280, whether or not the Commission made a full, faithful, and impartial inquiry into the matter. For me, like in this case, it is difficult to comply with this provision where you have not afforded the person the opportunity. How then can you convince anyone that you have made an impartial inquiry when the decision appears to be that a one-sided one, which you heard from someone who would definitely not incriminate himself, but will rather probably put the blame on another person? And that is why it's important that whilst we are waiting, I will still say that this is one of the instances where the president should at least put in place sufficient resources, expenditure and human, to ensure that this report, and if you issue a white paper, it should be done swiftly. If not, then he should make the declaration under the 285 so that immediately people can now take actions on this particular report, because the repercussions may be very serious and it's a very sensitive matter relating to politics.
The repercussions are serious, or maybe?
Well, I mean, for those who may be affected,
okay,
it's a very serious matter. And you see, even parliamentarians, unless you wait for the next 10 years before people like Ms. Anatete, if it is not overturned on appeal or, as is suggested, by the process of review. And with the review, I don't know whether a high court can even do it. Probably they could, or otherwise then the Supreme Court.
Okay,
so
let me try and give just a little background to the case and then hear from Abdul Malik on this one. And just a little background to the case. It's the facts of the case, and I'm reading from what Major Online reported. The facts of the case are that in 1997, the Ministry of Food and Agriculture entered into a contract with Delta Foods Limited to supply the country with 21,000 tons of American white maize to mitigate anticipated food shortages. Government could not pay the amount, and the company filed a suit in the High Court. The Attorney General admitted liability, for which a consent judgment was entered in favor of the plaintiff based on the terms of settlement filed by the parties. It sounds like the Wyoming payment. By the terms of settlement, government was to pay Delta Foods 2 million, just a little over 2 million Ghana cedis. According to the commission, after several demands for payment had failed, the company on the 28th of December 1998 notified government of its intention to file a suit in the United States for the recognition and enforcement of the consent judgment obtained in Ghana. Upon receiving this notice, the Attorney General, through the then Solicitor General, Mr. E.A. Addo, wrote to the attorney of Delta Foods, assuring him that the country was experiencing budgetary constraints and that the judgment debt would be paid in early 1999 after the new budget had been read. Some days after addressing the assurance letter to the plaintiff's attorney, the same Attorney General filed a certiorari application. We are talking about Dr. Obed Asamoah now. Filed a certiorari application before the Supreme Court, seeking to quash the consent judgment that the plaintiff had obtained in the High Court on grounds of nullity. I tell you, it sounds just like, very much like the Wyoming matter. Just that in that case, we didn't go to nullify it. The main consideration was that plaintiff should have sued the Attorney General, but not the Minister of Agriculture. The Supreme Court on the 3rd of March 1999 unanimously dismissed the certiorari application. The U.S. District Court of Washington, D.C. also ordered the government to make good its indebtedness to Delta Foods, the dollar equivalent of the judgment debt of 20 billion old cedis, that is about 2 million Ghana cedis. At the time the matter went before the U.S. District Court, was 8 million US dollars, is it? Okay. The U.S. court ordered the government of Ghana to pay that amount plus pre- and post-judgment interest of over 648,000 US dollars and 606,000 per diem respectively. Government paid the amount of 20.3 billion old cedis, that is, or 2 million Ghana cedis, to the company in March 2000. But on 10th January 2001, 3 days after the new government had assumed the reins of political authority, Delta Foods wrote to the government again, demanding an additional 4.6 million US dollars. They claimed that interest had accrued on the paid amount between 24th November 1999, when the money was paid, and 15th March 2000, when the money was eventually credited to their accounts. They also claimed the CD had depreciated over the period between when the judgment was delivered and when the money was paid, and government needed to pay the difference. An amount of US dollars 4.9 million was eventually paid to the company as the remaining balance of the judgment debt, plus interest, aside of the 20.3 billion old cedis already paid in April 2002. This, the commission criticizes, and hear what the commission said, in quote: "The major finding of this commission was that as a result of the improper or wrong decision of the Office of the Attorney General to further drag the matter to the Supreme Court on a mere technicality after it had admitted unequivocally the indebtedness of the government of Ghana to Delta Foods Limited, culminated in the concerned judgment of 8 September 1998. The government of Ghana was burdened with an additional payment of 4.9 million cedis, million US dollars, aside of the judgment debt of 20.3 billion old cedis. This constituted a huge financial loss to the state. I do not fathom how the Attorney General, after participating fully in the trial, submitting to judgment, could turn around to pray for the quashing of, I told you, sounds like just the Wayomi thing, could turn around to pray for the quashing of the very judgment he contributed in arriving at, on the basis of a mere technicality that in all respects, did not go to the roots of the matter in issue." The commission said. And finally, by that singular act, the Attorney General, I'm quoting the commission, by that singular act, the Attorney General, particularly the Solicitor General, did not exhibit candor and good faith to the plaintiff and the trial court that heard the matter, the result of which was the colossal sum of 4.9 million US dollars, which the state was made to cough out in addition to the original 20.3 billion cedis. So, Koko, again, like you said, this is the discretion of Attorney General under scrutiny here.
And I'm wondering whether if we do a little research into this matter, with all the details available, it will be only the Attorney General that will be singled out for commentary or critical observation. Because it was between 3 ministries: the Ministry of Food and Agriculture, the Ministry of Finance and Economic Planning, and the Ministry of Justice and the Attorney General. So I was a bit, intrigued that I didn't see any spotlight or searchlight on the Ministry of Finance and the Ministry of Food and Agriculture. If perhaps I haven't seen it, you can correct me, but I haven't seen. You know why? Because in 2000, And 4.
I'll admit that that part of the report I have not read in full.
Yes, I may have also skipped it. If I have, may I be forgiven. Because you see, 2004, if you look at this, this is report of the Auditor General on the statement of foreign exchange receipts and payments of the Bank of Ghana for 2.5 years, 2002. But this report was issued 2004. And it goes, is titled, that is part 3, Management Issues. Ministry of Food and Agriculture's contract with Delta Food Company Limited, loss of $4.9 million US. It says all sorts of things, but if you permit me, I'll quote some few portions. It says, our attempt to audit and determine the final disposal of the maize, the total amount realized from the 21 metric tons about so of the imported white maize and the specific consolidated fund account number for the lodgements of the revenue accruing for the sales proved futile, since the relevant books we demanded were not forthcoming from the Ministry of Food and Agriculture. Then he says that we think that since the Attorney General did not oppose the decision of the High Court, the debt of 20.3 billion should have been liquidated by the Ministry of Finance and Economic Planning to save the extra cost of $4.9 million. Meanwhile, we request the Ministry of Finance and Economic Planning and the Ministry of Food and Agriculture to explain the inaction which resulted in the loss of $4.9 million. We further recommend that Ministry of Food and Agriculture submit to this office all documents on the imported 21 metric tons of the white maize, and also a statement showing funds generated from the sale of the maize, as well as evidence of lodgement of same into the consolidated fund. 2. Ministry of Finance and Ministry of Agriculture should be more circumspect in handling contracts of such nature. In this connection, we expect government to always explore and take advantage of court appeals or alternate conflict resolution mechanisms to obviate or minimize the payment of such extra costs in future. Then paragraph 58 says something interesting. It said a copy of this report was extended to the Chief Director, Ministry of Food and Agriculture, on 15 July 2004 for his reaction on this matter. However, at the time of the compilation of this report on 1st October 2004, no response had been received from the ministry. Similarly, a copy of this report was also forwarded to the Chief Director of Ministry of Finance for his reaction on the above issues on 8th September 2004. However, as at the time of compiling this report, 1st October 2004, no reply has been received from the ministry. If you go to the report, it's page 98, the commission's report, it says there was nothing on record to show how the Ministry of Agriculture disposed of the consignment. There was also nothing on record indicating that the ministry sold it at a loss. The commission therefore recommends that the government should investigate and find out how the ordered maize was distributed or sold and what the proceeds were used for. Any public officer found to have contributed in the mess leading to the payment of the judgment debt must be sanctioned. This is the only way such public deals could be curtailed. But you see, when you go to, and this is the report 2015. Now, when you go to the Hansard, June 2nd, 2006, the Public Accounts Committee actually scrutinized this particular matter. And some of the points being made are captured here, but I think the commission fell short of getting some of the new details. And if you permit, I'll read, it's not too long. It says the audit could not, and this is coming from Hansard of 2nd June 2006, the audit could not, however, determine the final disposal of the maize. That is the total amount realized from the sale of the maize and the specific account into which receipts from the sale were lodged, coinciding with what the Auditor General said. But the committee itself, based on its work, said this: further investigations by your committee, that's the Public Accounts Committee, indicates that Accra High Court ordered the ministry to sell the maize and the proceeds paid into a special account, part of which should be used to settle the ministry's indebtedness. An escrow account was accordingly opened with the Agriculture Development Bank, and proceeds from the sale lodged into the said account. The committee has requested and obtained the bank statement on the operations of the escrow account and has forwarded it to the Auditor General for investigations. Information from the bank statement revealed that as at 24th May 2006, the balance on the account was 1.7 billion cedis. The amount has since been classified as an unclaimed transfer by the Agricultural Development Bank. The committee then made these recommendations in view of the fact that the debt owed Delta Foods has since been paid by government. Your committee recommends that the balance of 1.7 billion be transferred into the consolidated fund. The Controller and Accountant General is accordingly urged to ensure that a set amount is transferred by 30th June 2006 and the committee notified. The committee further recommends that the Auditor General should investigate the operations of the escrow account and report to the committee. I don't see any attempt here or any reference to these ones, and whether the Controller and Accountant General and Auditor General and ADB were called to help give us an update on this status as to what the finality is. I think that's a certain missing link.
Yeah. Okay. Abdul Malik Kwekubako taking us down, history on that judgment debt in which Obed Asamoah has been cited also, and Yao Pong's major concern is about the legal implications of these adverse findings against those individuals, which include that you could not become an MP or seek to become an MP, or you could not seek to become a president of the republic. Now, I don't know what you say. He took it from the point that the exercise of the discretion of the Attorney General should not be questioned in the manner that is being done. His professional, judgment should not be questioned.
I agree in total with him. A lawyer is as good as his brief. And every lawyer is capable only to the extent to which his knowledge of the law can take him. So in this particular case, indicting Obed Asamoah for what? For his legal strategy, for me, is far too fetched by the commission. It's far too fetched. On this matter, on the other matters, I gave them 50% and 50% to those who have been indicted. But on this matter, I disagree completely with them.
In his case, too, he wasn't invited, was he?
Yeah. And even and his case is worse because he was engaged in even trying to salvage the situation. Be it though a wrong move, but you could see an intention of an Attorney General who wanted to salvage the situation and then save Ghana from further paying some monies. So to question his professional competence, yes, but to attribute it to causing financial loss is, for me, far too fetched. And I think that the commission did not do a good work here.
Gabi, we can move on to, is it violence begets violence, can't we? Or you want to make a comment on this?
Just a quick comment. And I think the point I was making is what Kweku has added to it. And I think that's where I think the Justice and Powers Commission really has done us no favors. Because, it's like they were more interested in focusing on personalities and certain political personalities rather than on the processes and the rest. Because clearly, if you read even their own report, it was no fault of the Attorney General. There was a consent judgment as way back. Now, it was no fault of the Attorney General that government could not pay for food that he had ordered.
His problem is that this Attorney General agreed to a settlement payment amount and then turn round to go to the Supreme Court to try and set aside that settlement.
Before then, the finance ministry failed to pay.
Precisely. That's the point I'm making. And it could very well be that the Attorney General was only helping government. They were not paying, and he was using some technicalities.
That's
to,
obvious.
So I am very worried about really going all out to say that the Attorney General. How can a lawyer who has taken a professional decision,
in good faith,
in good faith, be told that you have it, because it's not as if his was not to pay money. His was to stop the money from being paid. And then you come out and say that he has caused financial loss.
But Imolde Drisu took a professional judgment in the Wyoming matter. It's a judge that has taken the blame.
What was the professional judgment?
Of dubious
No,
validity.
but what was the professional judgment? What was the professional judgment he took?
Yet we get up every day
No,
and we
what
accuse
was the
them.
professional judgment she took?
of
The professional
dubious
judgment
validity.
was initially that they had no defense.
Yeah.
Then subsequently,
So she paid.
Subsequently, that they were under a mistake that they don't have a defense. And then they went to settle. They went to do a settlement. Got a consent judgment, tried to set it aside. They didn't pursue it.
But
they were asked to pay only 17 million. They
I
went
think
ahead
you
for
forget
that.
about the
If you
Wyoming
bring
one.
the
It
Wyoming
has
case,
no-
there's too much criminality
Let's talk about
involved.
something else.
No, but you are saying that someone's judgment as
I'm
Attorney
saying-
General
No, I think Betty
should be questioned,
No,
and
that's a
someone
different-
else's
I think
judgment
Betty's
as
let's
Attorney General should
concentrate
be
on
questioned.
Obed.
No, I think Betty's one is
It's
different.
different.
It's different.
In
As for
Obed's
her own, we
case,
should question
No,
her, but not this
in
one.
filing the
Samson
writ, that was
played,
all right.
Okay,
that's
go on.
devil's
in
advocate.
Obed's case,
That's what Samson
in Obed's
did.
case, it was clear that government could not pay and was using some technicalities to delay the matter. That's how I see it.
Okay.
And really, it is. I think those were the areas, especially considering what Kweku Bako just quoted to us. Those were the areas that Justice Powell should have also concentrated on, because then we get a fuller understanding of how things happen and how we can avoid them in future.
Okay, thank you very much, Gadi.